For the sake of this video, let us say two persons were arrested for committing a crime together. Now one of them is bailed out. Now does the second one automatically becomes eligible because his friend was bailed out? The answer to that is yes. And this is called the rule of parity. Parity simply means treatment at par or equal treatment by the law. You see, the judges sometimes interpret the facts differently. In the same case, some persons are bailed and others are not. This creates a feeling of discrimination in the eyes of the person being arrested and also the public in general. And in order to uphold equality and consistency, this rule of parity was established. So does this mean that in every case, if one is bailed out, everyone will be bailed out? The answer is no. The rule of parity will only apply when the case of the person bailed and the case of the person applying for bail stands on the same footing. Their criminal background history should be similar, and various other circumstances related to their crime should be similar. For example, if that person getting bailed, he is charged with a minor charge of causing hurt. He caused some injury, minor injury, and the other person who is now applying for bail, he is charged with causing murder. Now, you see the difference of the charge between these two persons. One is charged with a minor crime, and the other one is charged with murder. So their case cannot be on the same footing. The rule of parity will not apply here. Again, let us say the person who got bailed, he is a first-time offender. He does not have any previous criminal background history. But this one, he is a habitual offender. He has many criminal cases pending before. He was convicted, let's say, 3 times before. Now, do you think the court will treat both of them equally? Equal treatment is impossible in this case. The rule of parity will not apply here. Guys, if you are liking the content of this video, please press the like button and share this video with your friends. I believe this kind of information and knowledge is essential for everybody to know. Okay, let us go on. One important aspect of this rule of parity is that it can only come into play when the bail order based on which we are seeking parity, that bail order has reasons mentioned in it, reasons as to why the bail was granted in that particular case. Now, every bail order does not have reasons mentioned. If you are a lawyer, you will know that not every bail order has reasons mentioned in those bail orders. Sometimes bail orders are very brief. They just mention that bail is granted. So, the Gujarat High Court in Dinesh Kumar Vasudev Nayak case, it held that while considering the claim of parity by one of the accused of the case, the order releasing the accused on bail did not contain reasons. The court in that case had no means of verifying whether the accused claiming parity stands on the same footing or not. The order granting bail is the only way of finding out that the cases stand on the same footing or not. The reasons which are given in the previous bail order, those reasons will determine whether parity is really there or not, whether the circumstances, whether the cases they stand on the same footing, whether their criminal background history is similar, on what reason the bail was granted in that previous case or in that to that other person. These things can be ascertained only by looking at the reasons which were given in that previous bail order. Now, if the reasons are absent, there is no way in any subsequent bail application the court cannot get to know based on what reasons did the bail order was passed. So the reasons in that previous bail application is of utmost importance. Now begs the question, if one can be granted bail based on parity, bail can also be rejected based on parity. Let us say one person bail was rejected, then any person who is applying for bail on that same case, his bail will also be rejected. And the answer is no, because the subsequent bail application was not even heard. Without hearing the subsequent bail application, how can the courts reject the bail application? Simply because the previous bail application was rejected. The subsequent bail application might come up with a new set of reasons for which bail should be granted. The subsequent bail application can have a much better ground. The Allahabad High Court in Sobharam versus State of UP states that there could be no parity in rejection of bail application. The reason is that when the bail application of one co-accused is rejected on merits, the other co-accused who is not a party to that bail application had no opportunity to make his submissions before the court. Without hearing the accused, the court cannot reject anybody's bail application. So the rule of parity cannot apply in case of rejection of bail application. The public prosecutor cannot make the argument of parity in case of rejection of bail application. So to sum up this video, yes, it is very important to know that the rule of parity cannot be taken to an absurd level so as to put the judge in a tight and straight jacket to force him to grant bail. The rule of parity is not the only consideration which the court has to keep in mind. In some cases, the judges should exercise their discretion. And having said all of that, if the cases are very identical and there is no real distinction between the two, and one of them is bailed out and the other is simply not, in those cases, in order to uphold uniformity and equal treatment by the law, sometimes the rule of parity should be applied. Bail should be then granted on the rule of parity. Thank you.